Hi everyone, we're just letting attendees join the webinar, so we'll be getting started in a few minutes, but thanks for joining the link so promptly. For those of you that have just joined, we're just waiting for a few more attendees to come in. We're now bang on past, but we'll give it a minute or two, just in case there's anyone who's scrambling for the link. Just got a few more people joining. And those of you that were early have heard me say this more than once. We're just waiting for a few more attendees to come in and then we'll get started. Okay, I think our numbers have settled in terms of attendees. I am therefore pleased to be able to kick off our webinar. Thanks so much to those of you that have joined other webinars in our bite-sized webinar series, which we've been running on the Wednesdays of this month of March. Today's webinar is about family law for immigration lawyers and immigration law for family lawyers. Now, that's an absolutely enormous topic, and we have a focused 40 minutes to go through some particularly pertinent points, but do get in contact with our family or immigration teams if you're looking for some more detailed advice for specific clients. So before you get some introductions from me and from Catherine, I just wanted to do a little bit of housekeeping. First thing to say is we will be finishing on time, so you can breathe a sigh of relief and go out into the sunshine afterwards if you can. And also just to say that slides will be circulated along with a recording of the webinar on Friday, in case there's anything that you have missed. So I will introduce myself and then hand over to Catherine to introduce herself. So my name is Rachel Francis. I'm a barrister at One Pump Court and I practice in family and immigration law and specialise in the intersection between those two areas. And like Catherine, often do advices on immigration law in family proceedings.
Hi, everybody. Welcome. Thanks for joining. I'm Catherine Robinson, and I'm also a barrister at One Pump Court. I'm in the immigration team. Before joining One Pump Court, I was an immigration solicitor. And as Rachel has mentioned, I quite often am instructed to do advices in family proceedings on the kind of different immigration elements. And so, yes, I'm going to pass back to Rachel and she's going to start.
Thanks, Catherine. So this is a little Woody's roundup of what we're going to be covering in the webinar. So we're going to start off with that amazingly hot potato disclosure of family documents into immigration proceedings and a little bit about the other direction, the EX 660 process, some relevant case law, and then the interaction between family proceedings, both public law proceedings and private law proceedings and immigration cases. So without further ado, disclosure of family documents into immigration proceedings. Now, this is quite a detailed topic, and we really could have a separate webinar just on this topic, but I'm going to take you quite quickly through the relevant law, procedure and guidance. And spoiler alert, HMCTS have this week issued some guidance for practitioners, which is extremely helpful and written in a very straightforward fashion about sharing of information when you're in family proceedings. And I've included a link to that on the next slide so that you can explore that at your leisure, and it's a good resource to be able to come back to. I'm going to take you through the kind of key pieces of law on point and just pull out some particular salient issues or salient points in relation to those. So the two statutes that you're looking at are the Administration of Justice Act 1960 and the Children Act 1989. And the particular sections are Section 12 of the Administration of Justice Act and Sections 97 of the Children Act. So what do we want to say about either of those? Starting with Section 12, this is the statutory provision which sets out what could be communicated about proceedings held in private, which for our purposes includes family proceedings, and what would not be contempt of court. Perhaps slightly unhelpfully, it doesn't set out precisely what will amount to contempt of court, but it makes clear that, for example, if you are communicating the whole or part of the text of an order, that would not amount to contempt, which is really helpful if you're wanting to share orders from family proceedings into immigration proceedings. It's also important to note in relation to Section 12 that this is a common law contempt. So that requires you to read it alongside the family procedure rules. And I've put on the next slide the relevant parts of the family procedure rules to which you will need to have regard. Now, there was a case that terrified immigration practitioners, a case of Nasrullah, where a paralegal was given a suspended sentence for contemptuous publication or dissemination of information from family court proceedings. And I want to just pause to say that to be found guilty of contempt, it is necessary to establish that the person who published information was giving information relating to court proceedings, that those were private proceedings, and you needed to know that you were giving that information. So if you did it by accident, you didn't know that the information related to court proceedings or that they were private, you would not be guilty of contempt. And that's probably a bit of a weighty start and has made everyone sort of begin to break out into a sweat. But I want to reassure you that this is a very unusual situation to find yourself in. And if you follow the guidance that's set out in the HMCTS guide that I will take you to, and also are mindful of the relevant statutes and the key cases and take advice, it's very easy to avoid any situations of difficulty. So just to keep on with Section 12, I want to speak briefly about really the key case on contemptuous disclosure, dissemination, publication of information, and that's that Kent County Council case, which is a real mouthful. And that was Mr. Justice Mumby, as he then was, and the helpful paragraphs on point I have highlighted there. So it's paragraph 72 to 73, paragraph 82 and paragraph 85. So what do those things tell you? So paragraph 72 and 73 define the meaning of publication. And in essence, publication for the purposes of Section 12, so when we're talking about contempt, is anything that the law of defamation would treat as there being a publication. So that could be oral, it could be written. And so it's a very kind of broad church. And in that case, the dissemination or the publication of information was documents sent to a journalist, a member of parliament, minister of the Crown, director of public prosecutions, Crown prosecutions, the police. And I should bracket that by saying who were not exercising child protection functions, General Medical Council. I mean, the person who had published those documents really went to town and did it to a very, very wide class of individuals. But that's the section, or that's authority for the principle of what does publication mean, paragraph 72 to 73 of that case. Paragraph 82 is a critically important paragraph because it sets out in list form, two separate lists, what section 12 prohibits the publication of and what section 12 does not prohibit the publication of. So I very often go back to this to check what's in the list of can or cannot be published. And then in terms of section 85, it's just a very brief note to say that when the court is considering whether or not a document should be published or disclosed from family proceedings into any other setting, it makes clear that the welfare paramountcy principle, which is the guiding principle for all decisions in family court proceedings, does not apply. So we're not looking at welfare paramountcy principles when we are talking about disclosure. So that's the key case for section 12. Just a few kind of points to note as well. What the case of A and Ward does at paragraphs 113 to 115 is to set out when something might become publication of information in family court proceedings and when it wouldn't. Because sometimes Catherine and I get these inquiries which say, oh, I want to describe what's happened in my client's life in a statement. Can I do that? Because that relates to family proceedings. And what A and Ward does very helpfully is describe the context that's required to put you in a situation where you might be at risk of contempt. Because just because you're describing a factual set of circumstances about your client's life, it doesn't mean that you are doing that in the context of and with the kind of background of care proceedings or private law children proceedings. So it's really important to go to those two paragraphs to think about, really, can I just put this information in a statement? Do I even need documents from family proceedings? Or is the context very proceedings led and in fact extracting information from the proceedings that can't be viewed separately, and therefore I do need to think about disclosure and going through that process and so on. Then the case of X, Y, and Z is about categories of information that can be lawfully shared. And I would commend those paragraphs to you if you're looking at that and cross-referencing it maybe with the HMCTS guidance. And then the Southend Borough Council item relates, I think, yes, that's to section 97. So let's pause section 12 on the final point that it's really important to remember that the contempt provisions apply in perpetuity. So even if proceedings have finished, you could be at risk of a contemptuous publication if you haven't got the right permissions to disclose documents that are caught by section 12. So that lasts forever. Section 97 is only in place or operational for the duration of proceedings. So once proceedings finish, family proceedings finish, section 97 has no bite. It ceases to have effect. But what section 97 says is that it in fact creates a criminal offence to publish information to the public at large or any section of the public, any material which is intended or likely to identify any child as being involved in any proceedings. So that's a bit of a statutory mouthful, but basically what it's saying is it's a criminal offence if a person publishes to a group of people or the public at large information that identifies or may be likely to identify a child as being involved in any proceedings. So where might this be relevant in immigration cases? It might be relevant if you're thinking about ongoing Children Act proceedings and ongoing proceedings in the tribunal or judicial review or whatever. And you need to think about, do I need anonymity? Do I need to have in-camera hearings? That kind of thing. One of the cases that I've included on the slide there is that Southend case, which is really talking about the difficulty in squaring the circle between section 97 and section 12. And it's kind of a point of reference, if you like. But what you need to be thinking about is when I am publishing information that I have kind of correctly identified is not going to lead me to being in contempt of court, am I publishing it to the public or a group of people larger than an individual, such that I might need to think about having an in-camera set of proceedings or having an anonymity direction. So that's a whistle-stop tour of those points. Then the second slide, which supplements that first slide, is this one. I've put notes to the Family Procedure Rules 2010. It's in particular parts or arts, excuse the typo there on the top line, 12 and 14. And I've put the relevant rules in there as well and the practice directions. Can be a bit labyrinthine, particularly if you're coming at this as an immigration lawyer. So I would really look at it by cross-referencing that guidance there on sharing information outside of court and family proceedings. Really, really helpful. If you're making applications to disclose documents, you're going to need to have regard to the relevant forms, and I've put the links there. Form C2 is the correct form to use whether proceedings are ongoing or whether they're not. And Form C8 is in the situation where you might need to keep your client's address confidential. You are able to do that by filling out their details on a Form C8, and the court will hold their details confidentially and carry on with proceedings. And only when the court positively decides to disclose your client's address will that confidentiality end. But that's the way to deal with it. So, next slide, practical considerations. Having got yourself on top of all of the law, having got yourself on top of all of the guidance, which is very helpful, very straightforward from HMCTS on sharing information, what do you actually need to do? Now, the first thing I would say is take advice from a family practitioner. I'm often approached, and so are a lot of mine and Catherine's colleagues in the family team, to provide this kind of advice if we have the crossover. And Catherine indeed drafts those advices often herself. You can get legal help to do that. You can pay for the one-off advice. It can be quite complex and it can involve disclosing quite a lot of information. So it's important to think about how you might fund it. Work out what it is you want to evidence and therefore what documents you might need. Your client in the first instance can share the family file with you to have a look at, and you might have a look through the index and think to yourself, what kind of documents are going to show what? But equally, if you're an immigration practitioner, you might think, I don't really know what the purpose is of these documents. So that's why it's really important to take advice from practitioners who have this crossover or specialise in family law. Think also about who the other parties are, including contact details and any issues about putting them on notice of the application. So if we think about two examples here, one is an example where you might be applying to register a child as a British citizen and your client is the mother and they were a victim of domestic abuse. Do you need to use Form C8 so that their details are confidential to the other parent who might have been the perpetrator of domestic abuse? The other situation is one I had in a case recently where we were seeking information and documents from care proceedings that had concluded for our client, who was a client in an immigration matter. And within the currency of the care proceedings, where that client was a subject child, there had been very serious findings made against one of the parents. And so quite properly, the child did not want their parent to be on notice of the documents that they wanted to obtain, because it would have given them information about their life circumstances now that could have placed them at further risk. So that involves some quite detailed representations and some argument at court about whether there was a requirement to put that individual on notice of the application. And they weren't given notice in the first instance, and then the court decided they didn't need to have notice at all. But it's just something to think about. You need your application fee, you need your forms, you might need a draft order. So again, getting that advice to help you with that drafting. And then keeping your application really focused and proportionate, because although this isn't a welfare decision, we have the kind of overarching cloak of privacy around family proceedings. And so it's really important that the list of documents is defined, the court knows why the documents are sought, we've got editing and anonymization, and we've got restrictions in place in terms of onward disclosure. Please also be aware of reciprocal information sharing. I have had some very difficult documents about clients in private law proceedings directed to be shared with the Home Office and UKVI by the judge because they were very keen for the Home Office to know what the parent had been up to, and it was within their power to do so. So I'm just letting you know of that. So I'm going to speed up because I'm talking for too long. But moving on, Form EX660. So this is the ability of the family court, or this is the form that gives the family court the ability to request information from the Home Office and UK Visas and Immigration, that's UKVI. I know it's very grammatically odd the way that it's put on the bullet point there, but that's actually the title for the form, not me having a grammar failure. This is what the form looks like. If you've never seen it before, these are just some screenshots. And this is a really streamlined, if it works effectively, way of the family court getting information about parents or children in proceedings. This links nicely to the case law and to the second case that's on the slide there, which is why failure to clarify immigration status, where Mr. Justice MacDonald was telling everybody off for failing to resolve the immigration issues of the child in a particular set of proceedings. And that resulted in an application after the fact to disclose documents and so on. There's also some quite unhelpful observations by Mr. Justice MacDonald about when the family court should or should not allow itself to have recitals in an order that kind of tell the Secretary of State or the Home Office to speed up with their decision making or make a particular decision for the benefit of a child. I think there's an element of latitude, but something to just be aware of. In terms of the other two cases on the slide, General Dental Council sounds like a brilliant read, but the reason I put it there is because there's a quite helpful summary of the judge's approach to disclosure, which is worth having a look at, seeing recent treatment. And then just one final case to keep in mind about children in care and change of nationality. This is where the Court of Appeal considered what level of court and what type of decision should be made when there is going to be the change of a child's nationality. It's just a case to be aware of if you have a parent coming to you who wants to register a child as British, for example, the need to look into whether they can hold dual nationality or whether there is going to be a displacement of the nationality that they currently hold by that registration and what steps you need to take as a result, potentially. Okay, that was a whistle stop. I'm going to hand over to Catherine, and thanks for your time and attention.
Thanks very much, Rachel, for that. So I'm now going to talk a bit about the interaction between family and immigration proceedings. Obviously, I mean, the kind of different variation of facts is, extensive, so it's difficult to kind of talk in general terms, but I'm going to try to. So I'm going to start by just looking at, I guess, the status of a final order in family proceedings, and that's either a final order at the end of care proceedings or a final order at the end of private law proceedings, and how that is viewed in law by the Secretary of State. The reference on the screen is to a Court of Appeal case where everybody was reminded that the Secretary of State for the Home Department isn't bound by any order of the family court. But of course, the Secretary of State, and that obviously also applies to the Immigration Tribunal, they've got to take it into account. It's an interesting reminder because I guess often when I'm approaching cases, I'm thinking, well, surely, what the family court says, is going to be determinative. But I guess it's just a reminder that it's not necessarily the case. And I mean, I have a case ongoing at the moment where at the end of care proceedings, a supervision order was made for 1 year in favour of a father. I'm now acting for the father in immigration proceedings. He's doing really well. He's looking after his child really well, and really, the local authority has kept involved, and so the child is still subject to a child in need plan, but that is really just because of the father's uncertain immigration case. And I am not sure how, I mean, I'm going to be arguing on his behalf that the fact that the family court made a supervision order, is an indication that the family court thought the best place, for the father to look after his child was the UK. But now we're a little bit down the line. I'm not sure how the immigration tribunal is going to approach that kind of now finished supervision order. So that is just, it's just worth keeping in mind that, yeah, that the final outcome from the family court isn't determinative. So I'm going to move on then to the position where you have ongoing family proceedings and also ongoing immigration proceedings. And the case on the slide here is an upper tribunal case, and in that case, the upper tribunal made clear or reminded us all that in general, the Home Office, so the Secretary of State's practice is that individuals involved in family court proceedings shouldn't be removed, because obviously they are participating in another set of proceedings. But that doesn't mean that those individuals have an automatic right to stay. And I think that's quite important to have in mind, I guess, particularly for family practitioners, because it may be that no application. So I guess in the situation where people don't have ongoing immigration tribunal proceedings, but they may not have any status, it's not, you can't just assume that the Home Office won't remove them. It's really important to encourage people to get immigration advice and to make an application to remain in the UK on the basis that they are participating in the family law proceedings. And then if we just move on to the next slide, again, this is a case where there were ongoing immigration tribunal proceedings, in fact, deportation proceedings at the same time as family court proceedings. And what's interesting here is this is the upper tribunal saying even in deportation proceedings, the right course would be for the appeal to be allowed on the basis that participating in family court proceedings is very compelling circumstances. And once the appeal is allowed, then the individual should be granted leave to remain. It is not appropriate now for the Immigration Tribunal to comment on the length of leave to remain that an individual is granted. It used to be possible for the Immigration Tribunal to make that kind of comment. But this makes clear that it's likely that the individual would be granted a short visa, a short amount of limited leave to remain, and then once the family court proceedings are resolved, it would be then the individual would have to make an application to extend their limited leave to remain, kind of on the basis of whatever final order they have obtained in the family court. Or obviously, I mean, it becomes obviously for parents, I'm thinking in particular, it becomes very difficult if the family court proceedings perhaps haven't, achieved the result that they were hoping for. So either, a child kind of being placed back into their care if it's care proceedings, or, you know, with a child arrangements order, with, I guess, a joint lives with order, if in fact you end up with much more limited spending time arrangements, it's still obviously that would still be enough to make an application to the Home Office under the immigration rules, along with your final order, and that should result in a further grant of limited leave to remain. But perhaps if you're involved in deportation proceedings, then again, if we go back to what I said initially, because what the family court says isn't determinative, and the immigration tribunal in deportation proceedings is, you know, weighing up the public interest in deportation, then it may be, you know, more difficult to be successful, but definitely not impossible. Again, it'll be about the evidence that you're able to put before the immigration tribunal. So the next slide is just really emphasizing the importance of communication between the two jurisdictions, which is obviously what we are trying to convey as part of doing this webinar. And it's, you know, it's important that this communication is able to function, and that the judges in both jurisdictions, you know, do have the relevant information before them. And again, that's, you know, I think in the family court, it's, you know, the EX 660 process obviously is very helpful and can work very well. But the difficulty is, you know, the information comes back obviously very factual, you know, from the Home Office answering the questions that have been asked. But sometimes the family court would benefit from, you know, a little bit more detail, or, you know, putting that information into context. And that's then when I guess it becomes important to get that advice from an immigration practitioner, because then they're able to set out, well, yes, you know, this is the history. You know, for example, their asylum claim was refused, you know, a few years ago, but, you know, these are the different options or the different things that may happen depending on, you know, what final order the family court makes. And then likewise, it's obviously, you know, important for immigration judges, you know, to see those final orders. Sometimes it's very helpful for them to see then more detailed information like care plans or parenting assessments. But then again, depending on who you're acting for, you may also take the view that actually maybe some of that information is quite historic and it would be less helpful to present to the immigration tribunal. So just really going back to, you know, what Rachel was saying about this information sharing, it can obviously, depending on who you're acting for, it can be very beneficial, but likewise, it can also be less beneficial. But anyway, working together, that's what the upper tribunal is keen to emphasise in this case, RS. So then next, I have put this up because I think, again, it's really important to remember, particularly in care proceedings. Say at the conclusion where, you know, you get a final care order and a placement order made, you know, ultimately final care order means that the local authority, you know, are in charge for that at that point. And so it's really to remind everybody that if the child's immigration status isn't resolved at that point, the local authority should be making an application to the Home Office for the child to be granted leave to remain. And it's this provision, this annex, children in care, which is particularly important. Obviously, it could have happened earlier in the proceedings, hopefully, but just if it hasn't happened, certainly at the point where a final care order is being made, you would want that to be, you know, highlighted in the care plan, you know, stressed by everybody involved, because again, Rachel and I, you know, down the line have acted for many people who have been in the care system and haven't been served well by their corporate parents because they, you know, no application, you know, for leave to remain was made. And, you know, they've got uncertain, irregular immigration status, and they're in a very difficult position. Likewise, I would be very keen for local authorities in particular to think about applying to register children as British, if that is possible. Just to flag, if a child has been, you know, born in the UK and they're 10, then the application to register them as British should be very straightforward. And so I guess I would urge everybody, you know, to think about or just remember about, you know, kind of planning for the long term for children, particularly those who have been involved in care proceedings. So then, time is short, but what I wanted to highlight is, I mean, look, there are so many points at which the immigration and kind of family issues can, you know, merge, interact, possibly clash. But one issue that I think is interesting is the issue of post adoption contact. So it would be particularly, maybe you have an immigration client whose, you know, child was adopted some time ago, but who is saying, you know, my my annual letterbox contact, that's just not enough. You know, I want to try and you know, have more contact with my child. You know, I've really turned my life around since the care proceedings. And it seems to me that there is kind of a move within family law towards, you know, kind of open adoptions or increasing the amount of post-adoption contact. We've got in the 2014 Children and Families Act introduced a new section 51A, which says when making the adoption order or at any time afterwards, the court may make an order under this section, and then, you know, providing for contact. Obviously it potentially raises lots of issues. I appreciate that, but I just think it seems to be an area of potential movement and opening up from a family law point of view that may be relevant and of interest in immigration cases. So I just thought I would flag that as a interesting area. That is all from me even. So thank you all for attending. We may have 2 minutes, 3 minutes for questions.
Yeah, I'm just checking. The Q&A box so far is empty, but fingers on buzzers if you want to get a question in before 10 past the hour. If anything's come up on...
Or obviously you can reach out to Rachel and I afterwards. We would be more than happy to answer questions.
Absolutely. So we'll just give it a minute or so in case anyone is frantically typing. But thanks so much to everybody for attending and for taking the time out of their schedule. We've had a request for the case law. Yes, that's all included in the slides, and you will have those slides on Friday when our wonderful PR rep, Emma Smith, is back from leave. She will circulate those along with a recording. And it looks like no other questions. So I think we will draw this to an early close, 2 minutes maybe to grab a cup of tea before your next meeting. But thanks so much to everyone for attending. And you'll see us next week. Well, not Catherine and I, but you will see James Shaw and Zubair Mughal, who will be giving us a webinar on ancillary relief and financial remedies. Super. Thanks so much, everyone. Bye.
Good evening. Bye.